Welcome everyone, and thank you for joining us today on Level Up Law, where we here at South Carolina Legal Services are leveling up your legal knowledge on the different areas of law that we practice in. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'm joined today by our attorney Phil Creel and our special guest Kabrina Bass. They will be talking about mediation. What is a mediation? What happens at a mediation? And the things you need to know to be prepared. Please note the webinar is being recorded. The recording and slides will be posted on our YouTube channel for South Carolina Legal Services later this week. Please keep in mind this is general information for the public and not legal advice. Always consult an attorney for any specific legal issues you have. At the conclusion of the presentation, we will provide information on how to apply for free legal assistance here at South Carolina Legal Services. Just remember today during the webcast, all attendees will be in listen-only mode, but be sure to put any questions you have in our question box, and we will do our best to answer them as time allows. Again, thanks so much for joining us, and I will turn things over to Phil and Kabrina.
Good afternoon. My name is Kabrina Bass. I am the Executive Director of Midlands Mediation Center here in Columbia, South Carolina. We are a community mediation center where we help families, individuals, as well as the community resolve their conflicts, improve relationship, and strengthen our community. So my role here today is to share with you how mediation work, what is mediation, and to go through a whole process of how this whole thing comes about and how we get into it. In order to get into the conversation about mediation, we have to first discuss why do we need mediation. The reason we have mediation is because there's this thing called conflict. Conflict is basically a disagreement or a dispute people may have. And so conflict can be seen both as a noun and a verb. In the image here, you will see the number 6 and 9, depending on which way you're looking at it. So if you look at conflict as a noun, they have a conflict. But if you look at conflict as a verb, their statement conflict one another. So looking at conflict as being both a noun and a verb, it can be seen in different ways. So how do we get into these things called conflict? Conflict literally originates out of either there's a limited amount of resources, there's not enough time, money, or property, as an example. There's some unmet basic needs. Somebody feeling that they don't belong, they're powerless, they're losing their freedom, or they don't have access to funds. And then there's different values that people have, different convictions, priorities, principles, and belief. And so when you have those types of things, anytime those things go missing or people feel that they're not being met or needed, that's when we head into conflict. And conflict has several responses. Soft response to conflict are individuals who just pretty much avoid it. And so they'll withdraw, they'll ignore it, or even deny that it even exists. And then you have another part of people who are hard conflict approaches. And these are the ones that get aggressive. They may even threaten or get angry. And so they show their conflict in a very aggressive way. But then there's one that sits in the middle between soft and hard, and it's called principled. And these are people who try to understand, they try to do problem solving, and they try to demonstrate a level of respect toward the other person so that they can find out what exactly is causing the conflict. So when we look at conflict, we have to understand that conflict arises from different people, from differences people have in goals, perception, understanding, values, expectations, status, culture, or behavior. So there's this whole thing of conflict coming because there's a disagreement. I like talking about the slippery slope of conflict because a lot of times people don't look at how awful conflict can become. You have people who, as I stated, avoid it or ignore it and things like that. In this image, they're called peace fakers because they pretend like nothing's wrong. But if you become too much of a peace faker, you get into so much of a denial, it can lead to suicide. And on the other side, you have peace breakers. And peace breakers, if they fight so much about it, these are people that take it to court and they have all these lawsuits and they fight, or either it'll lead to murder. So the two extremes of conflict can lead to either suicide or murder. But in the middle is this place called peacemakers, and that's where mediation falls. It's a place in the middle where you have an opportunity to make an agreement with somebody else and try to resolve conflict. that middle place takes a lot of work. The other two don't take as much work. So when you make the decision that you really want to resolve a conflict, you find yourself in this middle section of peacemaking. And so there are these model conflicts, and it has to do with self-determination. All the way over to the one side, over toward my left, you'll see that you have full control over resolution of these types of conflict. And this is conflict prevention or negotiating something with somebody else, a conciliation where you bring somebody in to help you resolve it. And then the mediator, where it becomes you have this third party person that's helping you talk through your mediation. But it can go all the way over where you lose control of the outcome to arbitration, where you share what it is that you believe that you deserve, and the other person share what they deserve, and the arbitrator makes a decision as to what happens. And then you get into litigation, where you stand before a judge and a jury, present evidence, fact-based information, and they make a decision as to what should happen. So the further over to the right that you go, the more control that you lose in the outcome. As long as you stand within the middle or over toward the left, you pretty much have full control as to what that outcome becomes. Even though you're working with another party, the two of you make a decision as to how it works. The further over to the right you go, the more evidence and information that you need. Further over to the left, it's just about a relationship and maintaining those relationships. And so that's what leads us into this thing called mediation. And mediation is literally rooted in the understanding that the persons that have the disagreement will make the determination as to how they want to move forward. So we see mediation as a forward-looking type of process where people look forward to what's going to happen. They're not looking necessarily as what's behind them or what the past was, but trying to see how do we move forward toward our future. And so in this mediation process, everybody that wants to be a part of it have to agree to be a part of the process. It cannot happen if there's one person that doesn't really want to participate in the overall process. Important thing to remember about mediation, the mediator does not decide what's right, what's wrong, what's fair. That's not their role. Their role is there to help you to walk and talk through the whole process. And so that's this whole scope of mediation in a very broad sense of the term, is that mediation is this process that allows you and the other person to come up with your own decision. Self-determination is a key word to understanding mediation. So when we look at mediation, there are several possible outcomes. One is you can come to a resolution. That is definitely an outcome that you can have. You can come to a partial resolution. You may not agree on everything, but there are some things that you all can resolve during mediation. There's even a tendency that there is no resolution, but there's a possibility that if you talked a little bit more about it, you all could come up with a future outcome. And then there's the opportunity that there will be no resolution whatsoever. And that's what we call an impasse. Mediation does not preclude litigation. Even if you participate in mediation and at the end of the day, you still feel that your issue isn't being resolved or that you need additional help or you want to present it to a court, you have that right. Mediation is a process to get you the opportunity to come up with agreement on your own. So when we talk about mediation, it's this real understanding that it is self-determination. The two parties that are involved make the determination as to how they want to resolve their conflict. That's number one. The second thing is mediation is voluntary. Even though a lot of time people come to mediation because they have a court order. The court order just orders you to come to the session. Nobody can force you to mediate. It's impossible because even if you are quote unquote court ordered to come to mediation and you really don't want to be there, you really don't want to come up to an agreement, that will hinder the whole process, and it's really considered not a good faith effort. And the mediator probably will inform the judge that the person that was participating did not come in good faith. So being part of mediation is a voluntary process in which you have to voluntarily be a part of the solution. It really works great, but it works better when people are in agreement to be there. It's non-adversarial. It's nobody on one side or the other side. It's everybody there representing their own interests and finding a way that they can come to a resolution together, making that determination on what it looks like at the end of the day. And it's future oriented. It's not always looking back to what someone did or what had happened, but how do we move forward from this point forward? How do we make this better? And then it is also confidential. Everything stated in mediation stays in mediation. You can never call somebody, a mediator, or parties that were there to court to testify about what was stated at mediation. However, in May of 2019, there was a case where the mediator was called to testify if the party was physically present. And so now we know mediators can be called about the process, but they cannot share any information as it relates to the conversation that happened in mediation. When I say the process, were the parties present? Was anybody coerced? Was there any threatening remarks made? Overall, what happened in the process, but not the information around or related to the actual mediation. And the last thing is that mediation in this concept is impartial. In other words, the mediator does not take one side or the other side. The process does not take one side or the other side. The process just affords people the opportunity to be present, to have a dialogue, and try to find a way to come to their own resolution. And so that is the part about mediation. If you all would indulge me in the chat feature, if you all can tell me what types of mediation have you heard of, or what type of mediation have you heard other people talk about? So there's a chat feature there. If you can just type in some of your comments, and that way we'll know that you're present and that you're hearing what's going on inside of this session. So I give a few minutes for you to type in the types of mediation.
Yeah, Ms. Bass, while they're doing that, I've got a couple questions I'd like to ask you. My name is Phil Creel, and I'm a staff attorney with South Carolina Legal Services. And I have been involved in successful mediations, both in divorce and custody cases and in eviction cases in the magistrate court. Now, you are the executive director of the Midlands Mediation Center.
Yes.
Who are the mediators that people are going to be working with?
At Midlands Mediation Center, our mediators predominantly are pro bono attorneys who volunteer their times to mediate. And we also have what we call community mediators, which are pretty much professionals like attorneys, HR professionals, CPAs. We even have a professor who, a scientist. So they're people that have advanced degrees who decided they want to also help people with conflict. And so I would say 10% of our mediators are people who have advanced degrees who decided they wanted to come in and help out with mediation. And so they volunteer their time to help people resolve their conflict. We do have, sometimes we do get college students who have an interest in learning about mediation, and they come and participate in the training. So far, most of our college students have gone to other communities to be a part of mediation. And so those are pretty much who our mediators are, but predominantly, pretty much what you'll see are attorneys.
My experience is that they are very impressive and effective participants in the procedure. So I don't think people should have any worries about them favoring one side or having their own agenda in the process. Now, what is the cost to participants for mediation?
So as a community mediation center, we really do not charge for community mediation. In other words, if two neighbors have a disagreement, they can come to Midlands. We provide 2 hours of mediation, but both parties have to agree to come because we can't mediate when there's only one person there, and we can't force people to be present for mediation. So there's no cost. Our family mediation, there is a charge because it's more complex, and we have to do a lot of administrative work on that. And it is a $50 administrative fee, and then it's based on your income, the cost for mediation. Mediation in South Carolina, court appointed, is $200 per hour plus a $200 administrative fee. And usually family mediations last anywhere between 2 hours to 4 hours. And I would say 4 hours when you have children involved, children custody, visitation, and things of that nature. So I always tell people our typical easiest type of mediation with a family is about 2.5 hours. Our more complex mediation can go as high as 4 on the average, and maximum we've seen is about 9 hours. And usually our 9-hour mediation is because one party lives out of town and they really want to get it resolved. We do recommend that if you go beyond the 4 hours, is that you may want to split it up and do 2 sessions, but people sometimes just want to get it done because it's already going through. So our sliding scale, if you make less than $10,000 a year, the fee is $20. But Midlands Mediation has a grant with Sisters of Charity this year, where if you make less than $10,000, the Sisters of Charity grant is covering your mediation. We also have for those that make between 10,000 to 20,000, it's $30 an hour. Those that make uh, 30,000, no, 20,000 to 29,000, theirs is $40, and then the next slot is the 30,000 plus, and that is $60, and then the next one is 40,000, that's $80, and the highest we go is 50,000. Those making over 50,000 is $100. So people often ask if we would raise our rates. As I said, mediation is typically court appointed is about $200, and that's a solid rate. So if a person, let's say, make over 50,000 and the other party only makes less than that or no income at all, if they were to go to the $200 mediation, they don't lose any money because it would be still $100 for them and $100 for the other person. So we really want to entice people that make the higher income to come to Midland so that the other person that does not make the same amount can get the price break and be able to afford mediation. So we really want to make it affordable. And so those are how our rates work. When it comes to civil mediation with businesses, if your business makes over $250,000 a year, our rate is at $125 per hour. If it is a business that makes less than $250,000 a year, our mediation rate is $50 per hour. The reason we can charge the low rates for mediation is because all of our mediators currently are volunteers, so they're not being paid for the services. The fees help us to keep the operation going so that we can serve our community at no charge, and so that we can make sure that we are meeting the needs of families who are in need. We've done a study, and a typical family would be out about $5,000 if they would go the regular route of mediation. Most families that make less than $30,000 a year cannot afford a $5,000 mediation.
Great. If you are sued and you're ordered to go to mediation, either in family court or in the magistrate court, do you have to have a lawyer to participate?
No, you do not have to have a lawyer. We recommend that you do have a lawyer, but you do not have to have a lawyer. And if you in mediation and you come up with an agreement and you're not real sure about the agreement, you have the right to take the agreement and take it to an attorney for review before you sign the final agreement. So oftentimes what we'll do is a memorandum of agreement, and before that final agreement is done, they can have an attorney look over it, and then they can sign the final agreement and submit it to the courts.
Do the parties to the mediation have any choice about whether it's during business hours or at night or anything about the scheduling?
Yes, parties have that choice. At Midlands, we pretty much have mediation Monday through Thursday from 9 a.m. to 5 p.m. But by appointment, we can make arrangements to have mediation later in the day. Currently at Magistrate Court, we hold mediations as late as 6 to 7 o'clock in the evening so that both parties can have an opportunity to participate. I don't know other mediators' schedule or how they schedule their mediation, so I can't say all mediations would offer that. We are even open to providing mediations on Saturdays as long as both parties are present. Because our mediators are volunteers, we don't really like for our mediators to take that time off and then people don't show up. So we're very leery in offering the evening and the Saturdays because these are volunteers and this is precious time that they're donating to our center to make sure they're helping individuals. And when people don't show up, it's not good for the mediator, and it kind of hurts our process as a volunteer center.
We have a couple questions from participants, and I would encourage any of our other attendees to send in questions if you have specific questions that you'd like us to address. One of the questions that we have is this attendee says, the Upstate Fatherhood Coalition, Anderson is assisting me with visitation. Can a judge order co-parenting? So I guess the question is, what kind of outcomes can be discussed in mediation?
So with mediation, there are laws. There are laws that the state has, and most, I would say, all the mediators know the state laws associated with custody, child support, visitation, and there's one more. And visitation, custody, and child support. That's the three. And so based on those, we pretty much work within those guidelines of the law. We cannot say what a judge can or will not do because we don't know. It is up to the judge. But usually your mediated agreement, as long as the parties agree on the mediation and is reasonable based on the law, usually your mediated agreement is pretty solid and the courts will accept it.
Okay. Another question was, I have a visitation case and DSS and the Sheriff's Department believe that sexual abuse is a concern. Are there any areas like sexual abuse or physical abuse which would rule out a mediation?
Yes, there are. Definitely domestic abuse would rule out mediation. Those cases are not supposed to be handled in the ADR process. If we are unaware of it, they sometimes get through because nobody notified us of there being a domestic violence issue. Same thing with sexual assault. Is if we know those aren't cases that we would handle in mediation because we don't have the proper staffing or training to do those. So we do ask the question if there is any domestic violence or any restraining order that we should be aware of. And people have been known to say there aren't any, only later to discover that there are some. So we trust the parties that they'll be open and honest in the whole process, including the intake part.
Okay, so if one side is saying there's abuse and the other side is denying it, does that kick it out, or is it more complicated than that?
If one party says that there is abuse, they're usually providing evidence of it. They're sending in a documentation to support it, either police reports or something like that. So that's what kicks it out.
Okay. I see that Elizabeth had a question about family court mediation, and I'm trying to, okay, the question is, what is the role of a child advocate and how do they participate in mediation?
That has been a very difficult question because some mediators, first of all, the court order indicates who should participate in mediation if it's a court order mediation. And the guardian ad litem, which is the what I'm presuming you're asking about, they are not part of the mediation process. But some mediators do contact the guardian ad litem to get their input as it relates to the mediation. Specifically, if a party says that they want the voice of their child to be heard, then you're definitely going to need to get the input of the guardian ad litem because the resolution rests in the input of the child into the process. And that's the only time I know of. But typically, the guardian ad litem is not part of the mediation process.
Okay.
Kabrina,
And I'm looking,
this is Susan, and it looks like you had asked what types of mediations people had done, and it looks like we have family court mediation and then circuit court debt collection mediation.
Awesome. You have any more questions, Mr. Creel?
yes. What do people, I mean, in an eviction case, it's pretty much either are you going to be evicted or not. What kind of issues come up in those cases that can be settled by mediation?
Most of those can, I can say this, most of the eviction cases that we get, both USA dealing with foreclosure as well as the ones we get in magistrate dealing with the housing department, most of those are settled. Rarely we find that they cannot be settled. We do have instances where there are other things involved where sometimes people aren't aware of the full picture of the situation, and that's because one party is holding back information that is not being shared. So the other party is not in good faith knowing exactly what's happening. And as I stated earlier, we can't force or coerce anybody to give information, but we can notify the court if we feel as mediators that it wasn't done in good faith. And we do those things to notify the court that there are some other circumstances that would indicate that it's not done in good faith. Now, we do not disclose what is it that's causing us to come up with the conclusion, but we do share that the overall mediation wasn't done in good faith. So I'm actually an advocate that if you are in a situation where it's dealing with eviction or even foreclosure, to see if you can get the other party to agree to come to mediation. Another area I can say that I'm almost at a 90% rate it'll be resolved is debt collection. Mediation works well with debt collection because both parties gets to sit down, and there's a judge in Lexington who always tells the story that in mediation, if you go to court and there's $50 on the table that both parties believe they're entitled to, the court is only going to award one party. But if you come to mediation, there's enough negotiation between the parties that each party can leave with a piece of the $50. It can be shared. One may get $10, another one take 40, but everybody leaves with a piece of the piece of the outcome. And sometimes mediation isn't always about money. Sometimes somebody just literally feelings have been hurt and they need an apology, and that apology can resolve that case and there be no dollars exchange. So I encourage people to try mediation, especially when it's an important relationship. It's better than going to court.
That all sounds great. How much time is scheduled for an initial mediation?
We allow 3 hours for our mediation, but if they go beyond that, and as long as it's productive, as I stated, we have gone as long as 6 to 8 hours, but it's on the parties. It's their choice and their decision if they want to move forward. And if everybody feels good and is moving forward and they're coming close to that resolution, most people will stay the course of it.
If the mediation is successful in a court-ordered case, then what is done with that? What happens to that agreement?
That agreement, it would be signed by all parties, and the current process, because we're in COVID, it's an electronic signature, and all parties will receive a copy of the final agreement, and that agreement is then submitted to the court and put in record.
Yeah, well, I guess you mentioned COVID, and that's an important issue. Are the mediations being done remotely now, or are they still in person?
It depends on which court you're with. Richland counties are all remote. Virtual mediation is being occurred, and I can honestly say mediation virtually is more private than mediation in person. because all parties are in their separate facilities. And one of the aspects of that is that they have to have their video on to make sure that there's no other party in the space. If anybody else is in the space, they too are required to sign a consent to mediate form, which means that they can never be used as a witness of anything that was stated in mediation. And the process seems to go better with online mediation because there's no urgency to get home or to get the children or do those types of things because you're already at home. And so we've had seen higher resolution rates with virtual mediation as opposed to face-to-face mediation.
Can the virtual mediation be done with a smartphone?
Yes, it has a camera on it.
Okay, so you don't need a webcam or a laptop or a separate computer to do it.
Nope, as long as you have your smartphone and a camera attached to it, which is part of a smartphone, you'll be able to do mediation. Upload the platform. This is a GoToMeeting, which will require you to upload that if it was being used there. WebEx, which is another application many mediators use, has an app that you can upload onto your smartphone. Does not take up a lot of data for the smartphone to upload the app. The app doesn't carry data. Your regular broadband would be used for the actual video conferencing that you're participating in, just like it would be used for FaceTime or Marco Polo or Google Meets.
Could you talk a little bit more about, you mentioned that the parties should not have other people with them. What were you talking about there?
In the court order, especially specifically court order, even if you do private mediation, the question is asked is who all will participate in the mediation. In the intake form, you identify who all will be present. So when mediation occurs, only those persons should be present for the mediation. If they're not party to the process, they have no input or no authority over the process, they should not be there because mediation is confidential. If another party is going to be present, it has to be with the agreement of all that's participating in mediation. In other words, you can't bring your sister to the mediation because she's your sister and expect her to be allowed to participate. It's only if the other person is comfortable with her being there, and then she would be just as responsible as everybody else as being part of that mediation to sign the consent to mediate form.
In the course of the mediation, does the mediator talk to both parties at the same time or just one, or do they go back and forth? How does that work?
It depends on the case. We all typically start with both parties being in the same space. Once again, on the intake form, there's a question: are you comfortable being in the same space with the other party? If someone tells us that they're not comfortable being in the same space with the other party, we would not start the mediation with both parties together. We would separate. And hopefully through dialogue, get an opportunity for them to be face to face. It is better when people can hear directly from the person as to where they are as it relates to the conflict versus them hearing it from a third party individual explaining what's going on with the other person. Because these people typically know each other, so they understand each other better if they can talk to each other one on one. If we cannot be together, then we do place the parties in separate space and go between the two parties to come up with a resolution if possible. If we can't come up with a resolution, as I stated before, it's called an impasse. But the beauty of it is both parties had an opportunity to hear the other side, to get an opportunity to understand where the other person is coming from. And mostly, I believe that once people have an opportunity to digest that information, there is an opportunity for them to come back and work out a resolution.
Again, if any of the participants have questions, feel free to put them in, and we will stop talking and address them. So, is it useful in the process for the parties to bring in documents or photographs or other things like that?
If they want to show it to the other person, the mediator can't do anything with that. The mediator is not weighing evidence or anything like that. So anything that they're bringing in to show, it is to show to the other person for them to understand, because that's not the mediator role. The mediator role is there to help ask open-ended questions to move people toward resolution. It is not to weigh evidence.
Okay. And do the parties communicate directly in the mediation process, or is everything through the mediator?
The best mediation is when people are talking to each other. And when they're talking to the mediator can't relate messages. Pretty much they need to be talking to each other, because that's where the resolution is with each other. It's not with the mediator.
Okay. So they can ask the other party questions in the course of the mediation.
And the mediator will set ground rules. There's no abrasive language. There's no insulting. And those ground rules are agreed to prior to the completion of the mediation. So we all agree to what's going to hold the conversation in mediation before we start the mediation. And all that's part of that consent to mediate. When you consent to mediate, you consent to the ground rules of how the mediation will take place in the format. And so if it comes to a point where the mediator feels there's disrespect or if somebody's saying something inappropriate, the mediator has the ability to stop the mediation at that point, to call for what we call a caucus, where they will separate the parties and talk to them separately as it relates to whatever's going on within the mediated session. So a good mediator knows how to work through the mediation process to get people to work together to come up with their resolutions.
Now, you mentioned mediation other than court-ordered mediation. What would be some situations which would be good for people to go to Midlands Mediation Center and try to get a situation resolved outside of the court-ordered mediation?
All neighborhoods. Some people call 911 for civil issues that are not criminal, and law enforcement cannot do anything with those calls. Those should be referred to mediation. And if we can get both parties to agree to mediate, those are issues that we can resolve at mediation. Debt collection, I think, is a number one thing that can come to mediation. If someone wants you to pay a debt and you don't have the money to pay the debt, ask them if it'd be possible for the two of you to come to mediation. And then we can sit down and talk about it and figure out a move forward that will satisfy both parties. Like I said, evictions and mortgage foreclosures are great mediation that work well through the mediation center. And family issues, caring for your loved one and trying to figure out who gets what weekends, or who's going to take mom and dad to the doctors for their doctor appointment, who's going to stay at the house on what days, and how that schedule is going to be worked out, are all great things that you can bring to mediation.
That's really great, and I wish more people knew about it and could take advantage of it.
We do too.
Now, is this what's on the screen? Is this another PowerPoint that you have to go through?
Yeah, this is the stages of mediation, because your questions are really related to the stages of mediation, and this is what typically people would go through in mediation.
Okay, would you like to go through that?
That'll be good. Yeah. So, okay. and it pretty much would go back to your questions that you had. The intake, scheduling, and preparation is part of pre-mediation, and it helps people to know what is going to happen. And so there is a process where if you call the Midlands Mediation Center or any mediator, they're going to send you an intake form to find out what exactly is going on. If it's court related, they will ask for all of your latest hearing dockets. They wouldn't go back to what happened at the beginning, but what was the last order that was created, so that they can get an idea of where you are with that. And then they'll find out your availability. When are you available, and the other party? One way of doing that is through a doodle poll, where you can send out availability, and people can select what's the best times for them, and then that's how we can schedule mediation. And then there's the whole preparation for the mediation, where the mediator takes time to hear why you're coming and to hear the other side's coming. One of the number one questions we ask in preparation is, have you talked to the other person? Because sometimes people schedule mediation and they've never taken time to talk to the other party. So that's important for the mediator to know. I think the other thing when we go through here, and I talked about it earlier, is there are some rules that are set for mediation so that people know what they're getting into. And so these rules help to, I always call, contain the mediation. So it holds it together so people can understand what exactly is being talked about. And one of the things we always focus in on is, it's not about the person that's sitting there, but what is the problem that we're talking about. So we try to make sure that people focus on the solution to the thing that brought them to the table. And then this opening statement, which Mr. Creel was talking about, when we start the mediation, we want to make sure that we understand that people that can make a decision are present, that people understand the process that they're going to go to, and that people understand the ground rules. The other part is that as a party to mediation, you get to share why you there. What is it that brought you to this? What is it, how you understand the dispute, and what is it that you expect to get out of it? And sometimes it is money, like I said, sometimes it's apology, sometimes it's the replacement of something, but being able to share with somebody what it is that you want, and the other person gets the opportunity to explain what it is that they understand about what happened, and what it is their perspective of how they want to see the outcome happen. And one of the main things that Mr. Creel was talking about is this exchange. The mediator allows for the parties to have this conversation where they talk back and forth about their issue. I had a scenario that I was going to walk through with this. Is about Miss Fluffy and the rooftop. And Miss Fluffy is a cat, and she got on the rooftop of a neighbor's car, which was a cloth roof, and scratched the rooftop, and it caused damage to the car. But the neighbor had a high allergy to cats, and when she went to feel what happened to the top of her car, she had an allergic reaction that caused her to go to the hospital, that created $180 worth of doctor bills. So she sued Miss Muffy's owner for the $1,500. And so that was a case that was mediated, where we talked through the whole issue of, it's fictitious, there's no Miss Muffin, but it was a case where we talked through how this would look. And so in the exchange, Miss Muffin's owner explained how she saw the incident, because she can't understand why this would cost $1,500 and the doctor bills are only $180. And then the owner of the vehicle explains their issue as to the amount of damage that was caused to their vehicle, as well as the doctor bills and future shots and medication to maintain these allergies with cats. So that's an instance where you hear both parties' side. And the things that you find out in those conversations is that the neighbors had a great relationship. They've always been friends. And at the end of the day, once they had this dialogue, the owner of the car was willing to pay for the medical expenses of Miss Muffin. Miss Muffin's owner was willing to pay the car owner for her medical expenses, and pay half on what it costs to get the car repaired. So they left there with both of them apologizing with one another, and there being a resolution with the payment as it relates to the actual damages. In the mediation, it may be necessary because Miss Muffin her owner may have something that they need to share with the mediator that they don't want the other party to know about. And so there's sensitive stuff as it relates to, the why you didn't tell them in advance that the car was damaged. That's stuff that you don't want the other person to really know. You get to tell that to the mediator. And the mediator will ask permission for you to share that with the other party if they deem it necessary to move the mediation forward. You don't have to, but it gives you an opportunity to do that. Mr. Creel, did you have any other questions?
Just, you've talked a couple times about confidentiality, and I'm not sure whether everybody grasps, can the things that you talk about in the mediation be used against you if it breaks down and you have to go to court, or there's later there are other things that happen?
No. No, and there's two things in there. There's confidentiality and this thing called privilege. So what you have with your attorney is quote unquote privilege. In other words, they're never to share that without your permission. That's privilege. That's between the attorney. But with confidentiality, it literally says is that what's contained inside of the meeting, inside of that mediation, is held within the mediation. It can never be brought before a court. And it has been tried many times, but every judge has refused it because the process indicates that everything that's stated inside of mediation remains in mediation. And that's why it's very important for the mediator in their opening statements to constantly inform all parties that everything in the mediation is confidential and cannot be brought up in court. And it's also important that the mediator get the signature of everybody that's in the mediation saying they consent to be part of the mediation, because that locks them into that confidentiality. So I hope that helps, Mr. Creel.
Yeah. And can all of that, the agreement to engage in the mediation, can all that be handled remotely?
Yes. Yes, all of that can be handled remotely. And that's why it's important when we're doing virtual mediation, we do ask the parties to have their cameras on, and so that we can see the space in which they're in. And so we pretty much have a solid lock on the mediation process. And since we've stated it inside of the, once again, in those ground rules, and it's part of that consent to mediate, that only the named parties are participating, then no one else can be brought forth as a witness to the mediation.
Okay, again, I'll invite anybody that's attending to give us a question if you have a specific question. Now, I see on the screen now that you've got some of the features of the agreement, and that's really interesting and valuable. Could you talk some about that?
I sure will. So when people come to remember, the agreement that is created is between the parties that are there. In other words, if they with Miss Muffin and the car owner agreed to pay for the medical bills and to pay half of the cost for the damage to the car. And they also asked that the car owner provides a receipt of what it cost them to get those damages repaired. So in that agreement, we have to be able to say, okay, this is when this event happened. This is the date of the mediation. Who is present in there is also part of that, is that these are the parties that were present. If there were any additional people, they would be named. Sometime when we do mediation, there is an insurance adjuster, especially with accidents and things of damage like that. And that person is also part of the mediation, so they would be included in the agreement as part of the demographics of who was present for the mediation. The opening paragraph would explain that these two parties agree to whatever it is that they agree to do. And in this case, you have the car owner agree to pay the medical bills and half of the damage on the car. And then Miss Muffin's owner Miss Muffin owner agreed to make sure that Miss Muffin is stays on the property, and that if Miss Muffin goes out, she would be placed on a leash or something and kept within 100 yards of the property that Miss Muffin's owner has. And so all that's inside of the agreement. One important thing about the agreement is we have a payment. So when will the payment be issued? What type of payment will be processed? In other words, on what day are you going to send the payment? Is it going to be in the form of a cash money, or is it going to be a money order? Or is it going to be a check? All that has to be written into the agreement. With debt collection, if it's going to be a payment plan, and when is it going to be paid? When is it considered late? What are the penalties if it is late? All that stuff is grafted inside of the agreement. Future evaluations in the case Miss Muffin and the car ownership. One of the things was is that none of this information will be posted to any social media platform talking about the cat or the damage to the car. That kind of things is put in there. And in there, if there's another issue involving the cat or the vehicle or anything like that, what will be done between the parties, and the agreement is that they will come together and discuss it before taking anything to a court environment or suing anybody. And then the disclaimers in there is that they all are of sound mind at the time in which they signed this agreement, and that they agreed that it is confidential what was said there and that it stays there. And then all parties sign the agreement when it happens. And so we get the signatures of everybody that's there. And so one of the other things is inside of that agreement is that there's a closure, that that agreement is read out loud by the mediator. That way we know everybody's in agreement as to what is being signed. And then everybody signs that agreement. And the mediator should celebrate what happened and the accomplishment of going through this process. Because if you come to an agreement, you spend at least 1 hour there with the mediator, minimum. And so that's a celebration of you investing that time. And then we reaffirm that it's a confidential conversation. And we then go through the process of taking care of any of the logistics as it involves payments or follow-up. But I also know there are times when there is no agreement. And so when we have no agreement, the mediator really tries hard to discuss, is there anything else that can be done? What might have worked? Or if they were in the other party's shoes, what are some of the other considerations? So it's really that one last time to see if there's any way that we can come up with any agreement. And even when there's no agreement, there's still that same closing. Is that even though there's no agreement, you had an opportunity to hear from the other person. You had an opportunity to know what are some of the things that could be done. And even after the mediation is over, there's still hope that you all can come up with a solution. And then the mediator explains the next step if the mediator knows what could happen. Sometimes people don't have all the information. Sometimes there's additional application that they may need to fill out. So that stuff is shared in the closing session so that everybody understands what happens. But you're still celebrated for the work that you did in trying to come to a resolution. We still reaffirm that it is confidential. And the last thing we do is go through that whole process of getting the fees and payments and anything of that and a follow-up if necessary. And then we always invite people to reflect on the actual mediation process and if there's anything that we missed out on that we may have covered that would have made it a better difference. And so, Mr. Creel, are there any other questions?
I guess just if the parties don't feel like going any further in the initial session, but they do feel that there might be something to be gained by getting back together again and taking it up again, maybe after they've talked to other people or thought about it. Is that a possibility?
That is a great possibility. That allows us the opportunity at Midlands. If it's a family issue and we charge you an administrative fee, we wouldn't charge that fee again because you've already paid for the paperwork. We already have your paperwork. And if it's a neighborhood, we don't charge for those anyway. So coming back would be, it's just the time that you're going to spend and getting that same mediator. That's probably be the most difficult, is trying to get the same mediator to have that time that you have available to be present. And if you're open to a different mediator participating in it, then we can make that happen as well.
Today is Giving Tuesday, and
yes, it is.
Legal Services is definitely giving people the opportunity to contribute to our work. How about the Mediation Center? Are you also giving people an opportunity?
Yes, we are taking any donation, and Giving Tuesday, we've set aside for training additional mediators. There are other people who want to help people in their community resolve conflicts. So we have a scholarship fund, and Giving Tuesday is when we raise dollars for the scholarship fund. It costs about $250 to train a mediator. That's bare cost for the actual training, the materials, and the staff that's used to do mediation training. But at Midlands Mediation, we provide 2 scholarships to the family mediation class done by the Law South Carolina Bar, CLEs, and that's a $1,300 cost. And so the funds that we raise on Giving Tuesday help us to send an attorney who could otherwise not afford to go through the course, gives us opportunity to send them to that class for free. They do volunteer for Midlands for, I think it's 24 mediation sessions to cover the cost of that scholarship. But it's a way for us to give back to the community and to increase the number of people out there with the skill set to do mediation.
That's fabulous. So I guess there's a need for more mediators.
Yes, there is a need, and I think when the close of this eviction thing ends, there's going to be a flood of need for people to mediate those evictions. So we're trying to gear up and get as many people as possible in the ranks so that we'll have enough volunteers to handle the those cases as they come through.
Yes, so you're talking about the eviction moratorium from the
Yes,
CDC that's in effect until December 31st, but of course we don't know
we don't
after
know.
New Year's what's going to come about, and we're not going to have a big change in Washington until the inauguration around the 20th. So
That's right.
who knows what kind of situation we're going to
Yeah,
be
but
in.
we want to be ready because families need to know that that there is a solution and there is a way to get through this, and there's processes out there that can help families, and so we want to help people navigate through it.
Well, that's great. Well, Ms. Bass, thank you very much for
Thank you, Mr.
participating in our
Creel.
level
This
up
was great.
Yeah, and
today. It's been a lot of really valuable information.
I want to jump back in. This is Susan Ingalls, and I do want to encourage
Great.
our listeners to um, contribute to both organizations on this Giving Tuesday. We really appreciate so much the excellent presentation from our attorney, Phil Creel, and Executive Director of Midlands Mediation, Kabrina Bass. This was just so much great information, and I just thank you so much for providing such excellent information on being prepared for mediation and what that process is all about. I also want to thank everyone who joined us today. We really appreciate your interest in this subject matter as well as others that we provide to you on Level Up Law. And please do remember that Level Up Law is a series of free legal events to educate the public on some of the most commonly faced challenges. You can join us every Tuesday at noon to learn the basics of a particular topic, as well as how to avoid pitfalls and protect yourself and so forth. And you will be able to find this episode and all of the other previous Level Up Law webcasts on our YouTube channel. So just go to YouTube and search South Carolina Legal Services and go to our Level Up Law playlist there. While you're there, be sure to like and subscribe. If you sign up for those alerts, you will always know when we have uploaded an episode of Level Up Law. Now, if you have an issue and you need legal assistance and you cannot afford a lawyer, you may be eligible for our free legal representation. So we want you to apply for help here at Legal Services by calling our toll-free number, 888-346-5592. Between the hours of 9 and 6, Monday through Thursday. Our intake office personnel are standing by during those hours to take your call. And remember that this is very important. You can also apply online at www.lawhelp.org/SC. So that's a great way to get your application in if the phone isn't an option for you. On that website also we have a bunch of legal resources that are available to the public. Those include checklists, articles, brochures, videos, our online classrooms where you can learn about all kinds of legal topics. So be sure and check that out. Again, everyone, we at Legal Services, thank you for tuning in to Level Up Law, and we do hope that you will tune in next Tuesday when we will be talking about domestic violence, family court versus criminal court. Again, an easy way to see what's coming up each week is to check out our South Carolina Legal Services Facebook page, or you can follow us on Twitter and Instagram, where we also post the information about our upcoming episodes. Well, again, let me thank Phil and Kabrina for an excellent presentation, and that concludes today's webinar. We look forward to having everyone back with us next week. Thanks for tuning in.